Well, I suppose starting mediation was one of the highlights because 40 years in practice as a civil and commercial silk, I got very tired of even winning cases, but clients being unhappy. I could see what their real problems were and realized the court couldn't help them with the real problems. And certainly in terms of relationships with the other side, after half a day's cross-examination, forget it. And so mediation seemed to be a marvelous way of, in fact, getting to the heart of disputes, getting to the heart of the problems that people have, and helping them to resolve them in a way that didn't involve standing up in court in public, being humiliated, being cross-examined, and coming out feeling dissatisfied even when they'd won, particularly when they saw the costs. It provides solutions that the courts can't, or arbitration can't. But more to that, when a client comes to a lawyer, he wants to tell his lawyer a story. And the lawyer says, well, I'm not interested in that. Just give me the facts. That's not relevant. That won't be admissible. I want this, this, this. And there's inevitably a feeling of dissatisfaction that the client hasn't been able to actually tell his story. In a mediation, of course, it's exactly the opposite. They tell the story. They tell me the story, and they tell the other side stories, which sometimes, curiously, the other side don't realize. Sometimes I've mediated cases which have started in arbitration. It's got too expensive, and therefore they decide to mediate. Other cases, it's part of a multi-tier dispute resolution procedure that you have to mediate before you can arbitrate. Other cases, after the arbitration is finished and people are dissatisfied, then they mediate. So there's no rule about it. All one's got to be aware is that the parties want to mediate rather than have an adjudication either from an arbitrator or, probably worse, from a judge. I can only speak personally. They can expect that I'm not going to sit and listen to lawyers telling me they've got a good case all day long. Certainly in the open session, I'm happy to have the debate. And if they do that, they've got to expect that somebody with my experience, forgive me, will challenge them if I think they're overstating it or they got it wrong. Not for any reason other than to make the client aware that it's not all black and white, and all one needs to do is to sow the possibility in the client's mind that his lawyer might not be right or his argument might not find favour with the judge. The more so where cases, as so often happens, depend upon witnesses giving evidence. Because I say to them, I don't want to know what the advice is you're getting, but I can bet you anything you like that what the lawyers have said to you is if the judge accepts our version of the affair, then this will be the result. And I said, you will realise, of course, that their advice is then dependent upon a third party. And one thing I do defy lawyers to tell me, without crossing all their fingers, is predict with any certainty what any judge will make of any witness, because we've all got it terribly wrong. And so that they can expect then, as I say, some challenging. They can expect some listening to what their real problems are. And I expect the lawyers to have done their work and give me a list of things that their client must have out of the mediation settlement, things they can't possibly live with, and things they'd like to have. And if I have that from both sides, you start marrying up where the two sides can possibly meet. People always say, what's your style? I say, well, are you facilitative? Are you evaluative? Are you transformative? My answer is very trite, but it's true. I'm whatever it takes at any particular time with any particular party in the mediation. I don't usually start off being evaluative because I'm in listening mode. But there will come a time when either privately or sometimes publicly, one's evaluative. If the lawyers are particularly difficult, I'll take the lawyers aside and have a good evaluation session with both of them. Transformative, as and when required, having the clients together, finding out what they really want from each other. And so it's a mixture of styles. I don't believe in one particular style. I think a good mediator should be able to do whatever is required to help the parties to resolution.